8:30 and January 15th for this NAP public policy meeting. We have a special format today, so each of you kind of had a special link. We are going to do a more of a continuing education style presentation today. Um, so we have Roz Roz will introduce the speaker shortly. Last month, however, I did introduce you guys to a new lobbyist team that we had. So we won't do really formal introductions, but I did just want to point out a few of the folks that are kind of being visible to the screen for you. So maybe if I call your name, just wave your hand. Andrea Rao. Did I say that right, by the way?
Sure did.
Okay, awesome. And I think a lot of you probably recognize Joe Bagnoli
Good morning.
and Thomas. Let's see, where's
Handsome.
Thomas? Is it is he
I'm
waving?
here. I'm
Oh,
waving.
there
And
we
it's
go. Tom.
Tom. Only my mother calls me Thomas.
Ooh.
So it's Tom.
Tom Hansen. Yep, and Tom's our lead for our the association. So you'll be seeing a lot of these folks here throughout the year, and next month we'll have a legislative update as well. So guys, welcome to NAOP
Thank you.
and to all of our members. I just wanted to make that quick introduction. And then lastly, I just want to thank all of our PPSF contributors. This is important stuff that we're talking about today and really every month that we meet. And your contributions make that possible. So without further ado, Roz, I will let you take it from here and give a great introduction.
Thank you, Sean, and good morning, everyone. We're happy that you're here. We're here to be a good resource for you and provide some education. And one thing that we have been following is how the lobbyist laws have been impacting commercial real estate. And we are very thrilled to have the executive director of the Campaign Finance Board, Jeff Sigurdson, to come here and help us understand how this law impacts our industry and how we can best comply with the law. They are not the police. They are here to be a resource. However, they do have the ability to enforce the compliance and also provide fines. So they're not here to they're not just in a figurehead. They certainly are here to help you. But if you choose to not comply, there are consequences. And so I just wanted to point out that this is why this is an important change for us to understand, and so that we know how to work around the law and also comply with it if we do fall into that lobbyist category, which can happen pretty easily, in my opinion. So without going on any longer, I will hand it over to Jeff. And Jeff, thank you again for being here. We really appreciate it.
Thank you, Roz. I appreciate the opportunity to sort of spread the word because, as you say, we have an enforcement authority, but we much prefer our educational approach or wings so that we can reduce the scenarios where we have to enter into some sort of agreement to resolve a scenario. I do have a PowerPoint. I'm going to try to share it with you all now. And hopefully that now comes up. Should be a lobbying political subdivision screen. That is going to be the kind of the focus here, just looking very quickly at the agenda. I'm assuming that you obviously are represented now by Andrea, Joe, Roz, and Tom, and they're going to be dealing with your legislative lobbying, your lobbying of administrative rules, if that comes up. But what I believe is the area of most concern for this organization is the recent expansion into all political subdivisions and what that may mean to you as an individual as you are now dealing with city councils and county commissioners and planning commissions and all those entities which were outside of the metro area at least excluded from lobbying, but which are now part of lobbying as of June 1st of 2025. We are going to talk a little bit about the components of lobbying. There's sort of this misconception that any sort of communication with government employees is going to be seen as lobbying. Actually, it's a lot more, the thresholds are a lot higher than that. There's only certain types of communication, certain levels of communication, if you will, thresholds that have to be met. And the communication has to be with local officials and public officials. And even then, it has to be for what are called major decisions. So there's sort of a decision tree, if you will, that you have to walk down to see if lobbyist registration is required. And then there is the issue now of expert witnesses and financial professionals, which were sort of carve outs from the definition of lobbyist and which may be useful for your members. Then I'm going to talk about lobbyist registration and reporting requirements. And then the issue of contingency fees prohibited for lobbyists, and my understanding is that might pose an issue for your organization. And then very briefly talk about the gift prohibition and certain contribution limits that only apply to lobbyists if you end up being in that category. The questions, I can certainly take questions at the end, but I have found, unfortunately, from doing presentations that if I drone on for 30 minutes, I'm going to lose you. So please feel free to step in and ask questions. I think Stephanie is monitoring that chat or how those are coming in. And I will occasionally ask her if there's anything here I need to address, but I'm really happy to take those as I reach a topic. I think it makes it more relevant, easier to understand what we're looking at. First, just real briefly, so what's a political subdivision? Well, it's probably just easy to say everything. It's all the counties, all the cities, all the school districts, all the townships, port authorities, all the metropolitan agencies like the Met Council, the MAC, regional railroad authorities. Frankly, the definition is any government entity that has the authority, this is below the state, of course, any government authority that has any government entity that has the authority to enter into a contract. Well, who isn't that? I mean, even joint power arrangements are going to have that authority. So if you're approaching any of those entities, they're covered now by the political subdivision definition. The lobbying definition, though, again, I just want to clarify that it means attempting to influence the official action of a political subdivision by communicating with public officials or local officials. So it isn't just any conversation that you have with a government employee. We'll talk about what local officials are, and that definition is kind of broad, but nonetheless, it's not any conversation. It's only conversations with individuals that fall within those groups. And the whole point of the conversation is that you have an ask. You want to change in an ordinance. You want to change in the zoning status for a piece of property. Whatever that ask may be, if that falls within the type of areas that a public or local official can act on, okay, now you have an ask. Now you have lobbying because you're talking to public or local officials. So those two criteria are met. But there's still a third threshold, and that is, did you do it enough that you've passed into what's typically called the $3,000 threshold, either for compensation for lobbying or use of personal funds for lobbying. So you even in this last scenario where you are attempting to influence action and you are talking to public or local officials, if it's a brief conversation, you're probably never going to reach $3,000. Therefore, registration is not required. But if all these things fall into place, then you are looking at registration as a lobbyist. So let's talk a little bit more about that trigger for registration. The $3,000 is an aggregate for compensation for lobbying in a year. So in other words, if you make a calculation and decide that for a particular action for city A, your compensation was $2,000, so I didn't go over $3,000, but then 2 months later, you're now talking to city B, or maybe you're on a different issue with city A, and again, you've reached another $2,000 in compensation. So in aggregate, you're over $3,000. When that happens, you now need to register for both of the lobbying efforts, and that has to occur within 5 days. If you're in a position where, okay, I don't do lobbying the majority of my time is doing something totally unrelated to trying to influence official actions of cities or political subdivisions, I should say. Then how do I calculate that? And that is set up in statute now, where you basically look at, okay, what's the percentage of time that I'm working on this? And then I take that by your gross compensation for the year. So obviously I'm going to use easy math here. You earn $100,000 a year. You're spending 5% of your time on lobbying. 5% times 100,000 is 5,000. Now you need to register as a lobbyist. And I recognize that may very well be the case with developers and realtors who, in fact, the majority of the time, of course, they're not lobbying. But if there is an effort, they need to compare their time spent on that activity versus their overall compensation. It doesn't have to specifically say in their contract, and you will lobby 10% of the time. If the reality is that you are lobbying 10% of the time, then you need to make that calculation to see if you've gone over the $3,000 threshold or whatever the percentage of time is. Compensation includes every kind of payment or for labor or personal services, including any amount withheld by the employer for payment of income tax. So again, you're looking basically at your gross income. There are a few exceptions for lobbyist registration. You don't have to register as a lobbyist for selling goods or services to a political subdivision unless an ordinance change is needed in order for that purchase to occur. I'm not sure this organization is going to be in that particular scenario, but if there was perhaps a case, if you're trying to have a political subdivision rent property that you own or represent, then that would perhaps be selling goods or services. And that in itself is not going to be a lobbying scenario because you're trying to sell something. Payment of an application fee or a processing charge for a government service, permit, or license is not lobbying or an activity that directly supports lobbying. So it doesn't count against the $3,000 is what we're saying here. And then we've got the expert witness and financial professional, which I'm going to cover in more depth here in a bit. But those are the two new exceptions for lobbyist registration that were just added at the last session. So Stephanie, anything quickly on those screens or?
Let's see. I do have a question in the chat here. So a developer seeking a zoning change for new development, how is that viewed in the context as a lobbyist registration, given the $3,000 threshold is low when factoring in legal, land use, design, etc.?
Yeah, it probably will require registration because if you go back, let's see if I'm going to really test the technology. If you look at the I don't know if that's not the screen I want. This is the one I want. Any activity that directly supports the communication is considered a part of lobbying. So if you are, if you are preparing for your lobbying effort by bringing in individuals to help develop information for you to use in the lobbying, that's part of the lobbying effort. And so, yeah, you do have, it's likely, I don't know, obviously, the specifics of that scenario, but generally you have to think in a broader term as to whether or not you're going to reach that $3,000 threshold. $3,000 threshold hasn't been adjusted in like 20 years. So frankly, I think it's fairly easy. At one time, it may have been significant enough to exclude a larger percentage of activity, but now I think most people will reach that $3,000 if it's any sort of serious activity at all. Okay, we did that slide. The next one is, sit back, because this is probably, to me, the most complicated part of dealing with political subdivisions, is that you're dealing here with local officials. And that, what does that mean? What's a local official? Because most government employees are not local officials. But it has two parts to the definition. The first part is fairly easy. You're a local elected official, or excuse me, you're a local official if you hold an elected position. So obviously your city council, your county commissioners, school board members, etc. If they hold that position because they are elected to office, then they're an elected public or local official, and any action that they take while acting in that official capacity is lobbying for that political subdivision. So kind of regardless of the act, if they're directly in charge of zoning changes or ordinance changes or adopting a budget, all of those sort of acts where they have to actually vote. Okay, if you're trying to influence that, you've come into contact with local officials trying to influence the official action of a political subdivision. That's lobbying. Now, the only question is whether you went over the $3,000 threshold. What is harder, and I guess I'll also mention quickly before I move on, is that it also includes an elected official that has the discretion in their official capacity to either approve or deny a government service or action on their own, basically by themselves, without bringing it back to the city council or the county board for a vote. That typically is going to be looking at different type of elected officials, maybe your county auditor, if that's an elected position, or the mayor, obviously. There are certain positions where they don't have to go back to the body to have a vote on an action. They have, through their position, the capacity to make a decision right then and there. That again comes under the heading of the type of decision, if made by an elected official, and you're trying to influence that, that's again going to be lobbying, and you have to now consider the other thresholds as to whether or not you need to register for that activity. The statute does provide some exceptions to that overall standard. Issuing a government license, permit, or variance that is routinely provided when the applicant is complied with the requirements of existing code or local ordinances. I'm assuming that's a building permit. If you've complied with all of the parts of providing that request to the city government or whatever the political subdivision is, well, that's just routinely provided once that form is completed, and that's not going to be lobbying. An action that's performed by the office of the elected official, which does not require their personal approval. Again, I guess I'm going to fall back on the county auditor. They obviously have a role in terms of taxes, but those sort of activities don't require their personal involvement, so that's not lobbying. Prosecutorial discretion exercised by a county attorney. Hopefully that doesn't merit anyone in this audience. And then the last one might, if you find yourself in litigation with a political subdivision over some action, those discussions, the legal discussions on that little litigation, the negotiation of a settlement, for example, that is not considered lobbying as well and is excluded from the definition. But here's where it kind of gets trickier, because there's a lot of ifs and frankly a little bit of gray in terms of this definition. A local official, in that definition, includes not only individuals who are elected to office, it also includes a person who is appointed to or employed by a public entity for that political subdivision, and in which the person has the authority to make major decisions, quote unquote, regarding the expenditure or investment of public money, the responsibility to make recommendations to a chief executive of the governing body about major decisions regarding the expenditure or investment of public money, or the authority to vote as a member on an entity that has that discretion. So if you take the first one, the authority to make major decisions, I'm going to try to use examples which may or may not be appropriate, but for example, I would assume that in most cases, the city engineer has the authority to make some major decisions regarding the expenditure and investment of public money. If you're talking about, changing an intersection and adding an off-ramp or whatever the case may be, those are probably major decisions regarding the use of public money. So those sort of decisions are going to be make that something that individual is now a local official. The responsibility to make recommendations to the chief executive or the governing body, well, that's probably your department heads. I mean, the fire chief may him or herself not be a local official, except that they have the authority or actually the responsibility to make a recommendation on what the overall budget should be for the fire department. Therefore, they are now going to be a local official. The authority to vote as a member on a governing body, What that's looking for, I believe, is the idea that many planning commissions or park boards are not only made up of elected officials, they're also made up of appointed officials. Certainly in Minneapolis, my understanding is that the zoning commission has some city council members on it, but it also has individuals who are appointed to serve on that entity. So they're not elected, but they have the authority to make a vote on something that affects the expenditure investment of public money. Therefore, they are going to be a non-elected local official. One thing that's also important to understand on this is that it's only when they're making these major decisions regarding the expenditure investment of public money does that local official designation kick in. In other words, let's go back to the fire chief. When they're making recommendations on the overall budget for the fire department, they're acting in that role as a local official. When they're making a decision about participating in the city parade or other decisions, that's not a major decision, and therefore regarding the use of public funds. And so those sort of decisions, if you're trying to influence it, they're no longer acting as a local official. It's only when they're dealing with the major decisions regarding the expenditure investment of public money does this kick in. If they're doing other types of decisions and you're trying to talk to them about that, they're not a local official for that discussion, and therefore it's not lobbying. And that's a mess. So I'll then go even make it worse by saying, well, who exactly is an employee? Now you would think about the people who are hired by the city or political subdivision, but it's more than that. It's also people who are serving as a consultant or independent contractor for that political subdivision. This was actually brought in by the League of Cities and organizations like that, because for many cities, they don't actually hire as the employee, the city engineer or maybe the city attorney or other professional positions. Those are actually contracted out as an independent contractor. Also an employee of a business that was contracted to provide the political subdivision with, again, those type of services or policy recommendations to the political subdivision. Those individuals are also considered to be employees. And so tie that together with the previous screen, they're now employees by definition for lobbying. And if they have what they're recommending is a major expenditure of public funds, they're now also going to be local officials. My point here is that when you're making the decision as to whether or not I'm actually talking to a local official, and if I'm not, then it's not lobbying, but if I am, it might be, then you have to worry about whether or not the individual is actually serving as an independent contractor or working for a business that's developing policy recommendations for the city. If so, that very well may still be lobbying. And then the last one, which is also has a fair amount of gray, is so what's a major decision regarding the use of public funds? It was recognized in committee that they can't set, or the legislature didn't feel it could set a hard number. It's not like they can say, well, okay, major decision is $100,000 or more, or it's $1 million or more. There was a recognition that, well, a major financial decision for Minneapolis is not a major financial decision for Forest Lake. I mean, that, or maybe I should have said that vice versa. A Forest Lake major decision relative to the size of their budget just may not qualify as for that in terms of the way Minneapolis looks at that question. So you have to consider not the dollar amount, but really how it's being incorporated into the political subdivision. For example, the following actions are set up in statute as being major decisions regarding the use of public funds. The development of operating and capital budgets by the political subdivision, regardless the size of that budget, that whole process is considered a major decision on the use of public funds. Whether to apply or accept state, federal, or private grant funding comes under that heading. Selecting recipients for government grants from the political subdivision is considered a major decision. And then this last one may be of interest to your organization. Tax abatement, tax increment financing, or expenditures on public infrastructure used to support private housing or business developments. Any of that by statute is specifically a major decision by a political subdivision on the use of public funds. So that probably brings in the majority of the actions that at least in my understanding, that your group may be interested in. There are a couple of things that, again, are excluded by definition. The purchase of goods and services that are set up through the operating budget. I think I mentioned that before. Collective bargaining on a labor contract probably doesn't apply to this organization, or participating in discussions with the party or the party's representative regarding litigation. Again, those are not considered by definition a major decision, but those above are, regardless of the actual dollar figures that are attached to it. Okay, I'm going back to you, Stephanie. Is there some questions on that?
All right, so first I'm just going to launch a poll question here. So this is just for people that want CE, just to prove that you are paying attention. So just answer the poll. Even if you don't need CE, you can just answer the poll to get rid of the little window that popped up. But I do have a couple questions that were asked here. What is the difference between an ask and simply explaining your project, that what you want to build on your land to the government?
Yeah, maybe that's going to be easier to explain once we get to expert witness.
Okay.
But no, I'll try to do it now too, as to set it up. The ask is, I mean, something's going to result from your ask, right? I mean, either the budget's going to be changed, the zoning ordinance is going to be changed, some other ordinance or regulation is going to be changed. Those are all asks. The administrative rules on lobbying acknowledge that quote unquote educational conversations are not lobbying. So if your conversation is, you know, we don't have enough apartment complexes in the city to meet the need of that particular demographic of people who are not ready to buy a house, but who are trying to move in the city, young workers, whatever the demographic is that uses rental property. And so it's important to have additional rental property. Now, if you go one step further, and that's how come we want to build this apartment complex, okay, there's the ask. But, you know, providing information on the type of housing density that the city has, the requirements maybe of the Metropolitan Council in terms of housing density, providing that sort of information is educational and is not lobbying. It's when it becomes then a way of supporting or in fact leading in to the specific request by the city council, for example, then at that point you've crossed over from educational and into an ask for particular action. If your entire conversation ends without you saying anything about a vote or anything about a specific project, just in general, this is the problem that the city faces, then that's educational and is not considered an ask of the political subdivision.
All right, I do have another question here. Okay, so section, sorry, I need to make this a little bit bigger. What section of 10A provides these exceptions regarding local elected officials? Looks like they found exceptions for non-elected local officials, but not for elected local officials.
Yeah, you know, to be honest with you, I don't have the statutes. I don't have the statutes memorized, but I will send Stephanie a list of the statutes to look at. They're both in statute and administrative rules. There are maybe 30 seconds to talk about this process. The change that expanded lobbying, the lobbying regulations in Chapter 10A were legislative, obviously, but they frankly didn't have a lot of detail. So immediately the board went into an administrative rulemaking process to try to flesh out some of these issues. And the legislature, I think, had a lot of feedback from individuals impacted in organizations impacted by the expansion to include all political subdivisions. And the legislature then turned around and passed the statute and said, guess what? The Campaign Finance Board will also produce a report on how the statutes on political subdivision lobbying can be improved and or clarified. And we did that in the summer of 2024 and provided that to the legislature in 2025. They adopted almost everything in terms of recommendations from that report. So there's kind of been a three-step here. You're all covered in lobbying. 2, here's the administrative rules to try to fill in some chinks in the, some areas that weren't very clear. And then 3, there's a set that came back and with feedback from organizations that are impacted, including, again, I've already mentioned League of Minnesota Cities, MGRC, Minnesota School Board Association, County, I always screw up their name, the Minnesota County elected officials, that's wrong. Whatever, all of these organizations came back and said, this is a problem. And so there were a number of changes made to try to clarify what some of these terms mean. And again, I'll provide a list of those particular statutes to Stephanie.
Okay, sounds great.
Okay, so moving on to the next one. Whoops. Yikes, what happened there? Try that again, sorry. Okay. I'm gonna have to try to share this again, sorry, for whatever reason that just died. Okay.
I can
we're
see it
back.
again. Yep.
Sorry about that. So there were 2 exceptions made. I guess you'd call them exceptions, where they tried to distinguish between what is lobbying and what is supporting lobbying, or part of the process that professionals may provide here to further a lobbying effort, but which is not in itself asking for anything. The expert witness was in place even prior to the addition of political subdivisions as a type of lobbying, but it was limited to, the wording used to be, you don't have to register as a lobbyist if the political subdivision and or whatever, the legislative committee asked you to come in and testify. In other words, the ask had to be from the government entity. It's now changed so that it's instead the expert witness is being brought forth by the lobbyist. It's no longer at the request of the political subdivision or the government entity. And so it's expert witness means an individual preparing or delivering testimony. And this is frankly almost a direct quote of the statute, but I'm more comfortable doing this particular part that way. Preparing or delivering testimony or a report consisting of information, data, or professional opinions on which the individual has particular expertise gained through formal education, professional occupational training, or experience in the field in which the individual is or has been employed. This is information that clearly is supporting the lobbying effort, but in itself, it's not an ask. It's not saying, the civil engineer, which is the example I'm going to come up because it was used in committee so often, is not going to say, you need to build this subdivision because of X, Y, or Z. Instead, their testimony is, look, this subdivision impacts the city's water supply, it impacts the sewer. So in terms of, will you need to modify or add a new water tower, I can address that. Here's the information that you won't need to do that. Here's the information on how we're going to tie this new subdivision into the existing sewer and water system. They're providing that sort of information so that the local officials who are making the decision have a more informed set of knowledge and, in theory, should make then a better decision. Again, it's fully recognized that the lobbyist isn't bringing forth the expert witness if the expert witness is going to say, no, this is a bad idea. It's understood that the information supports the lobbying effort, but in and of itself, it's not a request for the public officials or local officials to do anything. It's providing the information so that it's a better decision. And because it's considered to be part of the public dialogue on why this decision should be made, there is a requirement for the expert witness, and that is that the testimony has to be either made in a public meeting, or if it's a report, it has to be available to the general public. I mean, if it's a written document, it at least has to be available for those who want to examine that information, because after all, if this is technical information that leads to a better decision, then that should be available to everyone. And that was the rationale here, is that this is not a lobbyist. This is someone who's providing information that supports the lobby. Now, there is the question then in committee was, well, what does that mean? That they can't have an opinion, or they can't answer any questions? Well, no, of course it doesn't mean that. If after providing their testimony, there's a question saying, well, all right, is this the best option? Again, going back to the civil engineers, their position is that they have a professional obligation to provide the best approach. In other words, they may very well testify the city can solve this problem by doing A, B, or C. There are three options, but we are recommending, based on our professional knowledge, option A. Now, the city may do option B or C, but nonetheless, they are providing direction or a communication to the decision makers, to the local officials, as to which decision that they should make. But again, it's based on their professional knowledge of the scenario, not on whether or not, frankly, they have a vested interest in whether or not the subdivision is approved. Their interest is, okay, I've been asked to provide technical information based on my education and background as to what is the best way to solve this particular issue so that the project can go forward. That's the distinction. One is providing information that supports the lobbying effort, but it's not actually, again, asking the city council or whatever the entity is to do anything. The civil engineers, again, frankly, I just referenced them because that was, in fact, the organization that got, in my view, got this change in place, because they recognized that that $3,000 threshold level was something that their members often crossed. I mean, on a single project, they may be compensated over $3,000, and certainly over multiple projects in a year that they would be. And they didn't feel that they were lobbying. They felt that they were, again, providing this professional information. So that's sort of the genesis of this. That's what an expert witness is. It's different than a lobbyist because there is no ask. They're providing information that supports the lobbyist. That, however, does not mean that there isn't disclosure. And this is kind of key. The registration as lobbyist, again, is not required, but the lobbyist that they're working with has to identify the expert witness on the two periodic reports that the lobbyist files of their activity. And the information that they provide is fairly significant. They obviously the name of the expert witness, their employer, if any, the government entity that received the communication from the expert witness, and the specific subject on which the expert witness communicated. So, you know, Joe Smith or ABC Engineering, City of St. Paul, and the specific subject was the Ford Motor Plant, redevelopment. That information is very much similar to what a lobbyist would report. What does a lobbyist report if they are lobbying a political subdivision? Well, which political subdivision? What was the issue? I mean, it's kind of, and of course, we already know from their registration what their name is and who they work for. So it ends up being the same information, but it has the benefit of no further reporting obligation. And of course, the expert witness is not also bound by the same compensation and gift prohibition and some of the other items that we'll talk about here in just a minute. So there is still disclosure. It's very much like a lobbyist would provide anyway, but it does allow, again, for these individuals not to be into the lobbyist registration and reporting mechanism. And Stephanie, how about there? Is there questions on experts?
I do have a question. Okay, so if you are representing an organization as a developer, why is registration as a lobbyist required? Or to say it differently, what's the intent behind having to be registered as a lobbyist when you are identifying who you are and what you're trying to accomplish, and most actions that seem to trigger a lobbying action is in a public forum and meeting
Yeah.
or meeting.
The public forum and meeting, I understand was certainly brought up, saying that, you know, if you're asking a planning commission, for example, or the city council to do something, well, that's in a public meeting. Isn't that already providing public disclosure? And I guess the answer is, well, that's true if you're providing discussion or testimony at a legislative committee hearing as well. I think the belief here, and now I'm speaking for the legislature, so take that for what it's worth, that again, the greater good of disclosure isn't limited to only the state legislature. It isn't limited to state agencies. That the budgets of counties are, at least in the metro area, are, you know, $1 billion budgets. The larger cities are approaching that, and I think Minneapolis is over that. And when there's that type of financial heft, when the decisions that they are making affect so many people, there was a belief that this needs to, again, be something that's more formalized in terms of providing disclosure to the public. Is that acceptable to you as a reason? I don't know. But if you're wondering what is driving the legislature on this issue, it's basically that they believe incredibly important decisions are being made by local government, and yet the people who are impacting that are not necessarily going to be as easy to research and to be able to see those individuals unless, frankly, you attend the city council meeting. I think I at least heard this in committee, that there was the example that was brought up was the kind of the major development that's occurring in Rochester with a lot of public funds, and yet nobody was lobbying for that. That just didn't seem to be an answer that washed with the legislature, and that if it's lobbying when people are trying to influence us, it's lobbying when they're trying to influence Rochester or St. Louis County or whatever the case will be.
All right, and I have one more poll question that I'm going to launch here. So just answer just to confirm that you are paying attention if you want CE credits. Otherwise, do we have any other questions? You can raise your hand if you want to just ask it now. All right, okay, we got Sean.
Yeah, Jeff, thanks for all of this information. I guess if you are an owner of a piece of property, and you're not really getting compensation, you're going in because you have you want to do a building addition, and that per the city ordinance, it requires a site plan approval, for example, or one of the tenants is just outside of the use provisions within the zoning ordinance. If you're not really collecting a fee for this, do you still need to register, but yet you still haven't asked because it affects your property, but yet you're following the ordinance? Is that something that you would need to register for?
Yeah, one thing I think I probably skipped over when I talked about the $3,000 threshold. If you're not being compensated, then the second question is, are you spending over $3,000 of your personal funds on your lobbying effort? In other words, you haven't been hired to lobby, but to get something through, I'm going to be spending money, my own money, to to communicate or to lobby on this effort. By the way, by statute, that $3,000 does not include any travel or lodging costs that may be related to the lobbying effort. I recognize in the city that may be nominal anyway. And it also provides that the payment of any fees, for example, if there's a fee that you have to pay to ask for a variance in a building code, or that's probably a bad example, a variance in the zoning plan, that also doesn't count against the $3,000. So if there's no compensation involved here, it may very well be that you never need to register as a lobbyist. I think that's the kind of the out. If there's no compensation, then not that many people go over $3,000 in personal funds. Some, yeah, probably, but in most cases, probably not.
Were you CC'd on? Yeah, I think you were CC'd.
And did that answer your question, or was there another part of it that maybe I didn't get to?
Oh, I didn't realize I was still on. Yeah, kind of. It just feels like, as an owner, it's in order to comply with the variance, you have to do these things that the city lays out. And I just don't understand why, if I'm going, I understand if you hire a consultant to help you, I understand that. But as a building owner, many people go in for these things and they fill out the applications and they make the ask to rezone the property, but yet they're not really getting compensated. And even if they spend 3,000 of their time, the equivalent of $3,000, it just seems like, if the requirements are laid out as such and that's what you have to do, I don't understand why you would have to register as a lobbyist, because you're just following the law.
Well, again, probably, and maybe there's something here I'm not following, but if you're volunteering your time, there's no compensation for that effort. Then, and the permit fees again don't count against the 3,000. Then it's likely, I would assume, that in most cases registration is not required. Maybe I'm
And
subtlety here, but I think that would be the out.
and here's where I'm going with this too is, do we ever see a point where cities start to enforce this law, meaning, you come into the city, you have a project or you have an application that you want to, and they say, are you registered? And would cities have the ability to delay your permit process because you're not registered, I guess?
Yeah. I'm not sure if I know the answer to that question because I haven't heard of it occurring. I know there's been sometimes discussions about the idea that, well, I mean, I was going to go that I know that the legislature sometimes has looked at the issue of,
I think basically what it is
whether lobbyists have to identify themselves before they'll meet with them, but that probably doesn't really relate to your question. I'm not sure if I know the answer to that. I mean, that hasn't come up. I'm not aware of any city that's done that. I suppose it could occur.
Thanks.
Joe, you were saying something. I couldn't hear you very well.
Well, I don't think that was me that was actually talking, but I was just saying, and I can't control my own video or non-video, so I don't know how to do it. I'm sorry that I appear to be not visible, but Jeff, the issue for like that Sean was describing is if he's down there on behalf of sort of a tenant or something else, he's still nevertheless getting paid by Wildermere. He's not just down there, applying for something in his personal capacity. It's what he does for a living, and so he's not the tenant or the whoever is down that he's doing it sort of on behalf of certainly isn't paying him directly, but he has a financial interest in the outcome of whatever he might be. So that's where there's a funny gray. I don't know if it's a gray area, but that's why these questions come up where, unlike me, who is explicitly hired to go do X, in most of these folks' day-to-day jobs, there is conversations on behalf of tenants, on behalf of even vendors that are doing cleaning. Where should we park the car? What that aren't necessarily being directly compensated by the vendor or the tenant or but go into the operation of a building so that's where I don't know if I don't quite have a question there, but just a clarification maybe on what Sean was referring to. And I'm sorry, my face isn't visible. I don't know.
No one's complaining about that, Jonathan.
Okay.
And I probably didn't entirely understand the scenario. If I think I have to go back to one of the earlier slides where I was saying that, only a portion of what you're doing is lobbying, then you have to make that calculation as to whether or not that percentage takes you over to 3,000. I will say, Joe, that some of the things that I think you were mentioning clearly is not. I mean, where somebody parks,
Right.
or cleaning, or all of that stuff isn't lobbying.
Yeah.
And in terms of if the process for getting a variance is, again, I guess I would say administrative, you fill out the form provides that you've provided the information that's required by statute, you've paid your fee. That's not lobbying either. If you're saying that regardless of the existing ordinance, I would like a variance based on these facts, and this variance has to be approved, okay, that's lobbying. And now you have to make a calculation as to whether or not you've gone over that $3,000. And I apologize if I didn't get that
Right.
specific there. But I think that is true in those scenarios. That's why you have to walk through. Am I talking to a public or local official? Do I have an ask? Does it fit into one of the exceptions that are listed here? But if not, then I have to make the calculation as to whether or not I went over $3,000. And or you hire a lobbyist. I mean, if you don't, we're going to come to a reason, as I understand, at least that your organization has some reservations about registration as a lobbyist. I think we did everything on this slide. I guess I'm going to move forward here so we don't run out of time. I don't have too many more slides, but I got a couple. The other one to deal with then is the financial professional. I'm not quite sure if this matters too much for your organization, but a lobbyist that's attempting to secure conduit financing from a political subdivision may use the services of a financial professional to secure the financing, and then that financial professional does not need to register as a lobbyist. However, the financial professional does need to be subject to Security Exchange Commission regulation. So not just anyone's a financial professional. That term does in fact mean something. And again, the financial professional is working with a lobbyist to secure the conduit financing for a political subdivision. If I don't understand the scenario, but I guess there could be a case where a financial professional is not working with a lobbyist. Well, now they're going to be looked at as trying to influence an official action. And now they may very well be subject to registration as a lobbyist. The disclosure provided here is the same as for an expert witness. The lobbyist will disclose the financial professional's name, their employer, the city that they were working with, and then the name of the project that they were working on. So there is still disclosure to the public, but again, the financial professional does not need to register as a lobbyist. And that kind of matters because of, I think, the next one. Oh, I got one more I got covered before I get to, I guess, a concern area. So what does lobbyist registration and reporting consist of? Well, it needs to occur within 5 days of you determining that you're a lobbyist. There is no registration fee. That's the good news. No registration fee. It's just a 2-page form. You have to file 2 reports a year. In terms of lobbying political subdivisions, the schedule requires you to name every political subdivision that you lobbied. The general lobbying category, which is basically housing, is that, or maybe business regulation, something to that effect is going to be your general category. The specific subject, again, is going to be very much a drill down within the housing, what were you talking about. I was talking about this particular housing development. And then I've already mentioned the registration fee. The other thing is that termination is fairly easy as well. I mean, basically you send us a 1-page form saying I'm done. Whether that sort of obligation, a lot of people move in and out of registration as a lobbyist on a yearly basis, depending on a specific project that they're working on. And that's all fine. Again, there's no registration fee. I think though that the problem with lobbyist registration, or potentially could be at least, is that there's a general prohibition on your compensation as a lobbyist being in any way contingent on the success of your lobby. In other words, no person may act or employ a lobbyist for compensation that is dependent upon the result or outcome of any official action of a political subdivision. So if you're only paid if they approve a zoning change, that's a problem. And it's not even a fine, it's a gross misdemeanor. And this has been on the books forever. There was an exception made, and frankly, Joe perhaps could talk to it better than I. There was an exception made at the last session. The prohibition does not apply to an attorney or financial professional that is part of an effort to secure conduit financing through a political subdivision. So there was a recognition that in conduit financing, my understanding at least, is that it's the norm, or maybe even the requirement, that there isn't any payments made to the financial professional until the conduit financing is put in place. In some ways, this exception was only half needed. The prohibition does not apply to an attorney. All right, I think attorneys are not defined in terms of lobbying, so that I'm assuming that's anyone working on the conduit financing. Well, we've already said in definition that a financial professional is not a lobbyist. Therefore, the contingent fees paid to a lobbyist doesn't apply to them anyway. But it was nonetheless, I think, a suspender belt sort of scenario where we wanted to make sure that there wasn't any question as to whether or not conduit financing could be conducted on a contingent fee basis, and so that was put in place. When I had a brief discussion with Roz and Andrea about what might be of interest to this membership group, I understand that there is a concern about some cases a realtor may only be paid based on the successful change in the way property is zoned, for example. I think you have a statutory problem, and that may be something that you want to consider trying to address. But that is the contingent fee prohibition is already out there. It looks like there's some questions.
Bill, go ahead.
Thanks, and I appreciate everything. And please don't take these comments like I'm trying to bring rationalization as to the intent behind all of this. But I guess I just throw it out there that every single broker is on a contingent fee, and if that's a statutory challenge with this new, I mean, maybe said differently, I firmly believe that this might be something NIOP needs to talk with the legislature about, because I don't think this misses the intent, in my humble opinion, as to what they're trying to accomplish. When a broker puts their sign up saying this land's for sale or this building's for lease, or when a developer goes up and identifies themselves as saying, I'm representing such and such company, this is the development we want to do. I guess it's to me, I'm struggling as to what is the point of us having to register all these people as lobbyists, and they're going to have to do it for every single project. It just seems to me like if you follow this prescriptively as it seems to be laid out, it is a bureaucratic nightmare that I humbly submit adds zero value, much less it doesn't. None of this is happening under the covert backdoor meeting rooms, given the fact that it's out there in the public and there's no misrepresentation of who or what we're trying to accomplish. There wasn't a question there. It was more just of a rant to say this seems exceeding. This seems to totally miss any value, in my humble opinion, to our industry, other than a headache and a potential lawsuit or issue that's coming down the road.
John, did you have something as well?
Yeah, thanks. Yeah, just a couple things. I think one of the things that I think we could look at is just if a broker is only providing consulting for the entitlement change, that's one thing. But if it's tied to a normal transact, like, if you have a transaction that like you're tied to, that's a normal sale transaction that the whole real estate industry is tied to. And it just so happens that the buyer has a use that needs a land change. I think there's something to work through there. But Jeff, you had mentioned that expert witness and financial consultants were recent amendments to this rule. When did that change this past year?
The financial professional was this last year. The expert witness, let me think. Yeah, actually, that was this last year as well.
Okay. So in your advice, how do we make further modifications within this rule? Is it appeal to the legislature or is it to the CFPB board? How does that work?
Yeah, the board wouldn't have the authority to change this. I mean, these are all statutory provisions, not administrative rule. And frankly, I think, you know, you've hired some to be represented by some by experienced professional lobbyists, and I'm assuming that they can give you a lot better advice than I can.
Okay, fair enough.
Okay, we're
Oh,
almost.
I think we have one more from Joe here. Question.
And Sean and others, Joe Bagnoli. I was involved in the finance professionals on behalf of public finance folks who do conduit financings, and the banks were involved. As you might imagine, the banks who are regulated by the SEC and were really on edge about having to register as lobbyists. And frankly, we're saying, if we are required to register as lobbyists, we just may not issue debt in Minnesota. It was sort of, that was said at one point, but it will significantly impair our ability to do business in Minnesota, because we flat out cannot. It will go up through massive amounts of chains of regulatory chains in our entities, our banks, in order to allow us to do it. So we got that change for finance professionals involved in this narrow conduit financing, and then because they also, as you all know, and they're no different than you, they get paid upon close. So there's a very similar analogy. Obviously, we didn't work with you last year, but here about the particularly about the way you get paid on contingency. So this has come up in the last, I guess, I don't know, 10 days or so, where Roz, we started talking about this, but I think we know where to go, and we know Jeff, and whether or not the legislature has taken an extraordinarily hard line that where they're trying to apply a law generally to all sorts of different entities that interact with public legislature and local units of government. Everybody from architects and engineers to you folks, to homeowners that just want to. So that they've tried to figure out a law, and it is clearly a work in process. So that's the only other additional thing I can add. So Roz has told us we're to be on it, and we will be.
Okay, almost done. I do think that you need to be aware about the gift prohibition for lobbyists. If you do find that you need to register as a lobbyist, that then has a pretty strict gift prohibition. You can provide items of nominal value, $5 being considered nominal value. So you have coffee cups and pens. But there is, and this is kind of a common misconception, there is no exception for food and beverage of any value, unless, again, you're formally presenting at a meeting, you being the public official or local official. I think there's a belief that, well, let's go out for a cup of coffee and then I'll buy. You can go out for a cup of coffee, you can go out for a beer, but everybody's buying their own. It's basically what it amounts to. And then you can provide plaques if you want to a public or local official. There are other exceptions, to be honest with you, but those are the ones that are probably you need to be aware of if you find yourself registering as a lobbyist. The other issues on political contributions, there is a general prohibition on lobbyists making a contribution during the regular legislative session. And I think people who are new to being a lobbyist are not, for whatever reason, simply aren't, that isn't on their radar. And you can always have to provide your lobbyist registration number on a check to a state candidate, or because they have to track the number of contributions that they receive from lobbyists. So for them, it's important to know their volunteer treasurer may not know that you're a lobbyist, and so that becomes a problem for them, which is probably the last thing you want to create. So kind of a couple quick compliance issues. I will kind of mention one thing that Roz mentioned at the beginning, which is, so what's the board's role here? I mean, our role is to make sure that there's public disclosure. Do we have enforcement? Yes. But I mean, let's be realistic. We have a staff of 10. So how many city council meetings do you think we have a staff member at? That would be 0. This whole process in terms of regulation is based on complaints, where someone says that, hey, I'm working on this issue in Burnsville, and this group is too, and I know that they're not registered as a lobbyist. That actually happens fairly often. So it isn't so much that the Campaign Finance Board is in a position to enforce these provisions. It's that if you're lobbying for something, in many cases, somebody is opposed to that change that you're asking for. And if there isn't paperwork that they can look at, or compliance disclosure that they can look at, then they very well file a complaint, and now we have a whole process where we have to investigate that complaint. So that's the issue, and I guess that's the motivation to comply with the provisions as they currently are. Okay, that was sort of a down way to end this presentation. I apologize for that. But at any rate, if there are any last questions, I'm happy to take them. I know we're kind of running out of time here, but if there's anything I missed, I'm happy to take the question. I will provide the PowerPoint to Stephanie, and again, a list of statutes that you can take a look at as well.
Yep. One last question, fines or penalties for violations. I know you just talked about kind of how they come to your attention.
Really, I guess it really comes down to 2, well, maybe 3. Failure to register on time is $25 per day, up to $1,000. There is the ability to have an additional civil penalty of another $1,000, but frankly, that rarely occurs. Then the second is if a report is late, that again is $25 a day. So report periods have to be met. The other one that I already mentioned is the contingency basis. Well, that's actually not even the board. We don't have the authority to do criminal matters, but a gross misdemeanor would be referred to the appropriate county attorney. So that's probably the most serious penalty that you have to be concerned about.
All right. I think that's it.
All right. Well, again, thank you for the opportunity to talk to you. I know I didn't provide answers that you necessarily liked across the board, but we are trying to reach out to entities which are, so involved with lobbying political subdivisions, and I do appreciate the opportunity to talk to this group.
All right. Well, thank you, Jeff. Thank you, everyone, for attending, and we'll follow up with the PowerPoint and a short survey if you could take that as well. All right. Thanks, everyone.
Thanks, Jeff.